We're going to talk to you about embedded devices, and not the standard ones that we think of in terms of cell phones and iPads, but we've cooked up a lot of other examples. It was a lot of fun putting this panel together because we got to think about all these interesting scenarios that have come into the realm of legal discovery with all kinds of wireless services and continuous data capture. So we have Daniel Gary, who is a special master and mediator in e-discovery, and it's on the far left, and Daniel Gelb, Gelb LLP. We have a number of locations where electronic data and messages get stored these days. And as I said earlier, when we throw electronic devices, iPads, iPods, iPhones into the mix, we end up with data literally everywhere. And we want to talk today about when is it discoverable, when should you ask it, when should you ask for a way to preserve it, when a message that's mixed with your corporate data speaks about business. Does it become a business record? Is it no longer private? These are some of the legal issues we'll talk about. Clouds we might not have realized we're using. OnStar, car components collect data, which can be pertinent to product liability cases, accidents, things of that nature. GPS tracking, right? There's a lot of information that could identify where someone was when an accident happened in an 18-wheeler. Is that germane to a legal issue? Is that discoverable? Things of that nature.
I think something that's important to keep in mind is that with the proliferation of the electronically stored information world out there, we have so much data that's available to us. How do we reverse engineer the problem? With what occurred. I mean, what's great about technology is that we have these sort of digital fingerprints available to us, but I think people, particularly as being a practitioner, myself, everyone's always concerned about, well, am I going to leave a certain rock unturned, or realistically speaking, where am I going to invest the client's resources in terms of leveraging what's most important? I used to be a prosecutor. I used to be an assistant DA in Massachusetts before I went to private practice. And if you had a situation where let's say there was a particular homicide case, and the issue was black boxes would be recovered from vehicles, and then when cell phones became more of an issue with people being on them while they're driving, we started going after things like cell phone records to be able to determine whether or not somebody was on their cell phone at the time of the accident or thereabouts, or if they claim that they weren't at a certain position geographically, we would go after that kind of information as well. But how do you reverse engineer a set of circumstances, and what is it out there that's available to us readily available to us? Now, a lot of the discovery that you may want to go over with a digital forensics expert in the beginning of the case, in terms of actually being able to map out the landscape of what potential information there is out there that could be discoverable, may actually be readily discoverable from the opposing party because of the terms and conditions of the agreement that they signed with the service provider. I cut and pasted this from OnStar's website. And this is a perfect example, I think, of where I've experienced, not with respect to OnStar per se, but other types of information that's electronically stored based on service providers that the opposing party has engaged or uses, that they themselves may have the custody and control over the electronically stored information by virtue of the fact that the service, the terms and conditions provide for it.
It's probably reasonable if I'm a salesman and you find messages on the corporate exchange server, along with messages to my Gmail account, I'm probably reading from my phone. It's probably reasonable to ask for whether I saved any of them on my phone. Am I on solid ground assuming that a judge would say, yeah, you should send a forensic guy after Steve's phone because he's likely to have saved images or emails on his phone? Is that kind of emerging in the law?
Depends if the judge likes it.
Because that's a real embedded device. Because I can download something to my phone, right? And I can have it here, and it's not on any server anywhere else anymore. I can delete it from the server.
I know how you have your phone set up.
Yeah.
So if you're syncing your phone with your corporate mail, obviously the copies are going to be sitting on both sides.
But even without syncing, because lawyers tend to be early adopters of technology, so a lot of people are using their iPads.
Which ones do you know?
So they're not, yeah, well, I'm early adopter. But so you're not linked, so you're on a bank system, right? And your office is Windows, so what you're doing is you're forwarding what you want to work on to your iPad. So your drafts, et cetera, are on your iPad when you're working through the document, and then you only send the final document back to the servers at work.
So I tell people all the time, not to matter how good your lawyers are, that's really a litigation issue. I mean, is it reasonable where the copies, is this like the Dodger divorce case where the wrong draft is a 9-figure mistake? Ask Bingham. I mean, so it's all relative to what you're looking for and what you're looking at.
It seems like any given device, if we come to you, a technologist, right, we say, hey, here's the exact information you need, can we solve this? We can probably come to a solution either through beating each other up across the aisle or through some sort of agreement, right? We can figure out how to do that. But isn't there a problem that in a corporation, if you have 10,000 employees and 10% of them are using iPads, now you have data distributed. It's from an information governance perspective. How do you get your arms around where all that is?
Well, that's what I was getting. Hang on a second. That's what I was getting at before when I had my judgment thing slide. Right? So someone walks up to the IT guy with exactly the problem you stated. Give me every copy of this. And lawyers have been downloading versions of it. They're on the iPad. It's a very laborious task to figure that out. What's personal, what's a business record, what's not.
It's expensive.
It's
One iPad, not a problem, right? Probably.
And to Dan's
10,000 iPads?
Right.
Well, that's like
and to Dan's point earlier, is it reasonable to assume that happened? According to you practice every day. Yeah, it's absolutely reasonable.
I think what's happening is that the more these novel types of electronically stored information become accessible to the actual party of the litigation. So all these smart devices, if I can log on and control the security of my household, the information that I now have access to, I think is arguably in my custody and control. Just the same way it is with respect to your own Gmail account. It's something that is, I think, really important to keep in mind with respect to once you're doing the inventory of the information that you're looking to pursue is what is it that you're also looking to protect in terms of the strategy of if you're defending a claim, for example, and you don't want to give a piece of information over. This is why this whole inventory of your sort of peeling that digital onion, if you will, of all the different types of information that's not only embedded in the hardware that you use for software as a service in a company, or you do that laundry list. Well, if I don't want to give something over, the fact that I don't want to give something over, if it's not protected by statute, and if it's reasonably calculated to lead to the discovery of admissible evidence, there's probably going to be a problem with what the content of that information is. And I think what you're going to see more and more happen is that people that are going to start to put these sort of proprietary issues and concerns at stake are going to expose themselves more to discovery of what this is suspicious. Why will they not produce a particular type of information that's posted by a third-party provider? Is it the way they're using it? Is it a business method patent issue? What is it? So you have to really be cognizant of the strategic elements to certain requests that you make and when you do it.
Thank you all for your time.
Yeah,
The last slot of the day.